Meet Juan. Juan goes to work, pays his taxes, protects the environment, obeys traffic rules, and pledges allegiance to his country. And just like any other Filipino, he possesses the rights to life, liberty, and property. But it's not a walk in the park to be Juan. Juan will have to hurdle obstacle after obstacle to live a happy life and build a happy home. And forces, sometimes stronger than him, such as acts contrary to his constitutional rights, can deny him of life, liberty, and property. And now we are left with a sad and confused citizen. How do you think can the judicial branch of the government help Juan? The judicial power is vested in one Supreme Court and in lower courts established by law. The Supreme Court is composed of a Chief Justice and 14 Associate Justices. It may sit in full court or in its discretion in divisions of 3, 5, or 7 members. The Judiciary is composed of the Supreme Court as the highest court, the appellate courts, namely the Court of Appeals, Sandigan Bayan, and Court of Tax Appeals, and the trial courts, the first and second level courts. Imagine the judiciary as Juan's ultimate defender, armed with a gavel and the 1987 Constitution as its shield and weapon. Meet our superhero, Captain Justice. But from where does our defender draw strength? The judiciary is an indispensable department of every democratic government. In the words of Cruz, the courts of justice are the bastion of the rights and liberties of the people. As such, its independence is safeguarded by no other than the Constitution. For instance, the salaries of the judges and justices cannot be reduced or diminished. Judges and justices have security of tenure, which means they cannot be removed without cause. Justices of the Supreme Court can be removed only by the process of impeachment. Judges and justices cannot be designated to perform non-judicial work, and the judiciary enjoys fiscal autonomy, which means its appropriations may not be reduced by the legislature below the amount appropriated for the previous year, and after approval shall be automatically and regularly released. It means financial or monetary independence. But what is this constitutional superhero destined to do? Judicial power, as traditionally established, includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and as broadening of judicial power to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. As a general rule, courts will only entertain cases with actual controversies involved, except when it exercises its function to educate and inform the public about the application and interpretation of the law, and when it acts as a public conscience. This is called the power of judicial review, with functions limited to checking, legitimizing, and symbolic or educating. How about the traditional power of judicial inquiry? For the court to entertain questions, first, there must be an actual case or controversy. Second, it must be raised by a proper party. Third, it must be raised at the earliest possible opportunity. And fourth, when the decision of constitutionality is necessary to the determination of the case. But what is an actual case or controversy? There is an actual case when there are conflicting legal rights, which can be resolved by judicial intervention. In this case, the rights involved will have to be interpreted and enforced on the basis of law and jurisprudence. For a controversy to be appropriate for judicial determination, it must be real and substantial. But who is the proper party? A proper party is one who is sustained or is in immediate danger of sustaining an injury. The proper party is the one with legal personality to raise the issue to the appropriate court. But when is the earliest possible opportunity? If a constitutional question is not raised in the pleadings, it cannot be considered at the trial. If it cannot be considered at the trial, it cannot be considered on appeal. But this rule is subject to certain exceptions. In criminal cases, the constitutional question can be raised at any time in the discretion of the court. In civil cases, the constitutional question can be raised at any stage if it is necessary to the determination of the case. And in every case, except where the party is barred by estoppel, the constitutional question may be raised at any stage if it involves the jurisdiction of the court. But when can we say that the decision of constitutionality is necessary to the determination of the case? An act from any of the branches of government should always be presumed constitutional. This treatment is traced to the doctrine of separation of powers, which orders each department to respect or keep their hands off the acts of other departments. This means that if the case can be decided on other available grounds, such as the application of the statute or a law, the court will not take jurisdiction of the case. So for the court to act in its function of judicial inquiry, there has to be an actual case or controversy, a proper party, a timely questioning of constitutionality, and a necessity of deciding a constitutional question. The big question is, what happens to a statute when it is declared unconstitutional? There are two views on this matter, the orthodox and the modern view. According to the orthodox view, an unconstitutional act is not a law, so it confers no rights, imposes no duties, affords no protection, creates no office, is legally considered inoperative, as if it had not been passed. It is therefore stricken from the statute books and considered never to have existed at all. On the other hand, the modern view does not annul or repeal the statute if it finds it in conflict with the Constitution. It simply refuses to recognize it and determines the rights of the parties, just as if the statute had no existence. In our courts, while some parts of the law, such as vested rights, might still be considered valid based on the doctrine of operative fact, an unconstitutional law is generally declared to have no future effect and thus stricken from the books of statutes. That is how Captain Justice can save the day. Now Juan knows where to go and whom to call. He shall no longer be deprived of his rights to life, liberty, or property, with due process and equal protection of the laws.